Good afternoon, everyone. Today is November 23rd. It's 2023, I believe. It's 12 p.m. And today we welcome you to Garfunkel Wild's webinar entitled Best Practices for Terminating an Employment Relationship. My name is Andrew Zwerling. I'm here with my partner, Sal Puccio, and we're pleased and privileged to give you today's presentation. Just a brief explanation about Garfunkel Wild and about Sal and about myself. Garfunkel Wild, we're going on 44 years. We're a full-service healthcare law firm with approximately 90 attorneys in New York, New Jersey, Connecticut, Florida, Washington, D.C. And by full service, I mean healthcare, litigation, managed care, corporate, compliance, finance, mental health, law, biotech, IP, and we've even branched out into other industries as well over the years. Sal and I, we have been litigation attorneys and employment attorneys for decades now, handling matters from the local trial level through the United States Supreme Court. And in certain respects, Sal and I are a little different from your average employment lawyer because we wear two hats. We do regular day-to-day employment counseling, if not on a daily basis, certainly on a regular basis, putting out fires as they arise. But we're also litigation attorneys. We try cases. And when we try a case, we see how one of our clients handles something well, maybe how they handled something less than well. And then we use that information to inform our day-to-day counseling as well. For those of you who aren't aware, but based upon the numbers of lawyers who did register, today's presentation is for CLE credit. I'm just going to read this little content that we're required to do in order for you to get CLE credit. The content of the course is acceptable for both newly admitted and experienced attorneys. Please be sure you continue to stay connected on Zoom until the program concludes in approximately 12:45 to the 1 o'clock range. You'll be receiving and eligible to receive 1 CLE credit in professional practice. For New York CLE attendance verification purposes, we're going to give you a course code at the end of the program that you need to record. Tomorrow, everyone, whether you're seeking CLE credit or not, will receive a CLE outline that will flesh out the slides that you'll be seeing today. You'll also be receiving a recording of this particular program. Sal and I have given many presentations of this type in person with crowds as large as 200 people, online with hundreds more. But we always have the same approach and structure. We really encourage questions throughout. Now, obviously, we can't see you raise your hands, but you have a chat feature on your screen. So if you have a question as we're going along, type out your question. We'll see it on the screen in the chat box and do our best to answer the question in the moment or at the end of the program. Or even afterwards, you can always feel free to reach out to us. So for today's webinar, and by way of introduction to the content and the subject matter, employers often face claims by former employees that their employment was terminated for an unlawful reason. And whether those claims are valid or justified or correct, a wrongful discharge claim nonetheless is going to result in a costly legal battle that can go on for years. It can lead to adverse publicity depending upon the case. It can hurt morale and productivity in the workforce. And what we're hoping to accomplish in today's webinar, is to address key issues for you to consider when terminating an employee. Sal and I are going to provide you what we feel are some best practices to minimize the risk of a wrongful termination or wrongful discharge claim that will enhance your ability to defend these claims or respond to them, whether it's pre-litigation or a litigation context. We're going to provide you with guidelines on how to establish legitimate reasons for termination, not to contrive them, obviously, but how to lay the predicate for a proper termination, how to assess potential legal risk when you're contemplating whether or not to terminate someone, how to create and maintain relevant documents, including policies and performance reviews that may prove critical in defending allegations of a wrongful termination, how to deliver the termination properly and professionally, which can also go a long way to minimizing the risk of a potential litigation, and finally, how to protect proprietary information, trade secrets, and the like once you do decide to terminate somebody. So with that said, we're going to move along.
So first step in this discussion today is preparing for the termination. And we understand that there are going to be some circumstances, and hopefully a far and few in between, where you're going to have to make a decision on the spot to let somebody go. And that's going to be those extreme examples where you catch someone in the act stealing, maybe you catch someone in the act physically assaulting or touching another employee. And the reaction has to be, okay, you're terminated, collect your stuff, and let's get you out of here. But more likely than not, the instances that Andy and I are talking about today come up when an employee is just not meeting your performance expectations, or they are just not necessary anymore. That position has been made obsolete or combined with another position. So when you have the opportunity to plan, you should. And what Andy and I try to do with all our clients is come at it from a very practical sense. And like he said, the best way you can look at these is from the end coming backwards. What I mean is, what's the worst case scenario? What's going to happen at the time of trial? And we want to have those questions answered before you say, we're going to terminate someone. So with that said, it's don't rush. You might have to take a day or 2 days to think through the process and make the right decision. I'm dealing with the client right now where it's been a couple of weeks to a month where we felt initially, if you would have made the decision, you probably could have sustained it and would have been found to be correct and justified. But there were some open issues, and we wanted to work through those open issues. So we gave another 30-day performance improvement plan. And you know what? The employee just didn't get better. We waited for the Thanksgiving holiday to come. We're going to offer some severance, and we're going to separate going forward into the holiday season. And I think that's the right outcome, because that should limit the potential exposure and emotional claims from the employee. So again, don't rush. What you want to think about off the top is, what considerations are out there that I should be concerned about? And the best way to start is engage your HR. If you have a company that has human resources department, go to them, get their input. A lot of times we see managers, supervisors acting quickly, shooting from the hip and just saying, you're fired, that's it. But there's so many things that supervisor or manager might not know that are going to be important. Is the person on some type of accommodation? Did the person complain about discrimination previously? And all this could come back to haunt you in the end. So reach out to HR. If you don't have HR, go talk to someone in upper management. If you have outside counsel, reach out to us. I mean, I know Andy and I do a lot of good work with our clients where the first step is they know to pick up the phone. And I always say it's better to spend that 20 minutes or half hour time with us than you act. And then we see it all the time. 3 months later, I just got served this lawsuit. I got served this Division of Human Rights complaint. Can you help me? Sure. Give me all the paperwork and information. It's going to be more costly in the long run. So some considerations: are there potential legal claims? Do I want to give severance? Is there a written contract I have to follow? Are there other legal implications like warn notice? We just had a situation last week where a company decided to close down a particular operation pursuant to a transaction, and the warn notice wasn't realized or thought about until the lawyers got involved at the back end. So we had to wait now 60 days. So these are the type of things you want to think of upfront. And you can also really avoid a lot of situations, because what I'm finding in today's current climate, a lot of employees, and it goes back to the pandemic, are ready to leave. They want to leave. They're waiting for you to terminate them so that they can bring some claim. But if you wait a little bit and you're patient and you do it the right way, you're going to protect yourself in the long run. So understanding the applicable laws that are out there that we have to keep an eye on. Just because an employee, and we saw some questions come in earlier that, can you touch on what analysis I have to do for an employee that's at will? Well, generally speaking, unless there's a particular employment agreement in place or some other controlling document or something in your operating agreement or shareholders agreement, employee standards are typically at will, meaning you can terminate someone without cause. You can terminate someone with cause. That said, it's not free rein to just terminate people whenever you think it's appropriate, unless it's justified. For example, someone may have a particular accommodation that's been provided to them by management, by HR, that they can come in a little late, or that they can take longer breaks, or that they can go to take family to doctor's appointments. And if your basis for terminating an individual is because they come in late, they leave early, and they're missing during the day, well, now you've just violated one of their basic legal rights that they had to an accommodation. So, these things need to be thought through in terms of, is it the appropriate time and circumstance? And just because that person is at will doesn't mean that you can fire them for that particular reason. Again, discrimination is a big one. We see that come up as an excuse or a reason why someone was terminated from the employee side all the time. I always tell my clients, it's very rare, if ever, does an employee get fired and it was their fault, meaning it's somebody else's fault. And usually that default is the employers, you, the folks that are on today's webinar. So keep that in mind. There are federal discrimination laws, state, city, local discrimination laws, all that you have to keep in mind. There's too many states where we practice now to go through each one of them, but we'll do that with you on an individualized basis to check those. A big one that I'm seeing, I think the hottest issue right now with respect to claims against employers relates to disability and claims under the ADA or those local laws regarding claims. And the last piece I'll touch on for understanding applicable laws that is oftentimes overlooked, and many of the folks in my office always ask me the question, because it's one of my areas of specialty, is what about wages and hours, when to pay somebody out, and we'll talk about that today, but also, have you been complying with wage laws the correct way? If not, and you terminate that person and they bring an action, that could turn into a class action that you just never anticipated. So again, these are all things you can look to protect against when you're just making a simple termination in the next couple of weeks.
Before we go on, I just want to piggyback on some of what Sal said about understanding applicable laws. Picking up a phone, call us. You know, those few minutes you spend with us now can prevent an ugly costly litigation down the road. So an example of understanding applicable laws, and Sal mentioned disability claims. We have handled many situations where a client will call up and say, we have an employee, he or she or they're still out, they had surgery, they've exhausted every form of leave possible. We can fire them, right? And the answer is no, you still can't fire them, because you have to engage in an interactive dialogue to see if there's a reasonable accommodation for unpaid leave that can stretch out a week or 2 or 3, depending upon the circumstances, especially since the threshold for undue burden has been escalated based upon a recent, not so recent at this point, Supreme Court ruling. So the knee-jerk reaction might be, well, they've exhausted leave, I can terminate them. No, understand the applicable law. There's another step you have to follow. Another example of understanding the applicable laws having to do with the issue of retaliation. Again, Sal pointed out that we're in many jurisdictions. We represented a teaching hospital, and the issue had to do with a couple of residents. It wasn't a termination context; it was a discipline context. But the salient point is still relevant to today's topic. And they were being disciplined for violating certain safety protocols and policies in this particular department at the hospital. But the practical reality when we went and investigated that they had made a complaint against the department head for harassment, that had been resolved. He then started to enforce these rules against them, rules that he had never enforced before, right? So again, at the surface, it's let's discipline, or depending upon the context, let's terminate. There's a violation of the policy, okay? You take a step back. What laws may be implicated? Well, it's retaliatory, okay? And so you can face exposure to liability for stepping in too quickly if you don't understand the particular, legal landscape. Other factors to consider when terminating: has that employee filed any internal complaints? Again, if you terminate that individual, and you may still decide to terminate that individual if the facts warrant it, understand the risk associated with that, where they may raise a whistleblower claim. Or Sal had mentioned wage and hour. We handled one particular case where an individual was terminated. They were actually caught on video shredding original documents. There's an easy one, right? And the person was terminated, claimed disability discrimination, which was baseless in the extreme, but turns out there was a wage and hour issue that the employer or the client didn't pick up on before they terminated this individual, and they ended up having to pay a whole lot of money on the wage and hour piece. So you want to give close scrutiny to understanding the applicable laws before you jump. Develop and consistently apply policies. Having proper documentation in the form of policies and procedures it's significant to your ability to avoid or defend against a wrongful termination claim. If you have poor performance or some form of wrongful behavior that leads to an employee's termination, it's real helpful to litigators like Sal and me and our colleagues to go into court and say, hey, it's clear. Policy said you can't do X. He, she, or they did X. There you go, right? It's violation of policy. But here's the thing with policies, they're only as good as if you consistently enforce them. If you let somebody come in late and don't enforce a policy against them, and then you enforce it against somebody else, you may say, well, I let so-and-so come in late because he or she is a really great performer, okay? They're the best in my department. Yes, but that's fine. But then if you go to enforce it against somebody else, it may raise a red flag. It may instill in them the mind that the real reason you're enforcing against me is because I'm a member of some protected class. So again, you have these policies, they're there to protect you. It could be a violation of a failure to communicate if you're going to be out policy. We have a bunch of those going on now. Maybe it's the holiday season, I'm not sure why. People just not calling in to say they're going to be out for the day. In New York City, you can't even demand a doctor's note if someone's going to be out for less than 3 days. But at the same time, if you have a policy that says they have to call in sick, we had one that just came about recently. The person didn't call in sick for 3 days. So you had a failure to communicate violation, you had a job abandonment issue. Again, policies, having written policies that you can point to are going to be your best friend. With regard to policies, most of these policies, employee handbooks are online these days. People aren't giving out hard copies. To the extent you can, get some form of acknowledgement that the employee has either read, understands, or acknowledges receipt of the policy, or at a minimum, you are able to prove that they've had access to the policy. Because again, if you get a lawsuit, even if they say, well, I didn't know there was a policy, but in their orientation, it was explained to them how they can access the policies on some intranet or online system that you have in place, that'll still help us in the long run to say, no, they had access to the Smith policy or the Jones policy. Again, I can't stress enough about policies. They're great to point to during a litigation, but apply them consistently, okay? Because you're going to raise those red flags. If you deviate on behalf of one person as opposed to another, even for some reason that may appear to be justified to you, like you're the best performer in your unit, wants to leave early on Fridays during the summertime, and you go, it's okay, you leave. And then Sal comes up and says, hey, can I leave early too? And you say no. All right. Aside from creating morale issues, aside from, creating some employee engagement issues, you may raise those inferences in the minds of Sal in this particular scenario of, wait, why am I not allowed to leave? Oh, it's because. All right. So keep this in mind.
So next step to take would be consulting any applicable employment agreement. This is kind of a separate category. It's in that situation where the individual is not at will and there's an agreement that's in place. And in the healthcare space, a lot of our physician employees, nurse practitioners, RNs even, and your C-suite level of employment agreement that sets a particular term, how long they're going to work. That might have requirements with respect to restrictive covenants after the time ends, or would have specific provisions with respect to what's a for-cause event, a without-cause event, what are the payment obligations. And what you'll typically see is if someone's terminated for cause, you can do it immediately, and you might not have to pay them any other additional money because you're firing them as of that day if one of these events hits. So oftentimes someone calls up, and it just happened last week, they wanted to terminate an employee. They were ready to go and said, okay, well, is there an employment agreement? Yeah, I think so. Let me dig it up. They dug it up and we looked at it and we said, okay, well, what's the reason you're gonna terminate this employee? Well, they're just not doing a good job, and there were some problems with performance. They were showing up a little bit late. So, okay, well, that's not articulated in the for-cause section. So you're gonna have to give this particular individual 90 days notice, or you're going to tell them we're terminating you effective in 90 days, pay them out for those 90 days, and then you can come back and say, oh, well, we can't trust them to work for us now for the next 90 days. And that might be okay. That might be the conclusion that we reach together. But if you just terminate them and don't pay the 90 days, and I've had this happen in the last 3 to 6 months, I know Andy's has one too, you get that letter from the other attorney that says, you just fired my employee and you didn't pay, where's the 90 days pay that you owe? So, it's something as simple as that, everyone has to think about in terms of making sure you take the necessary steps. And what we often find out is when someone comes to us and says, well, we want to fire this person, what are our options under the agreement? We can look, we do a little bit deeper digging, we ask some additional questions, and we might be able to find ways to say, well, that termination actually does fall under the for cause reason, and we can let the person go for cause, or at least in the termination notice, put information that is indicative of a for cause termination. So there are a lot of factors to consider when looking at an employment agreement, whether it's a notice provision, a payout provision, a severance provision. More and more agreements now contain some type of severance. And it's important to look at all of those. Something I just saw recently that happened, and it comes up from time to time, but one in particular employment agreement had a provision that said, you will be paid out your final wages after you do X, Y, and Z. And there was a litany of events. And I looked at that and I said to the client, well, that's going to technically conflict with state law that requires you to pay out that last wage the next pay period. So we have to reconcile the two. We have to figure some way that you're comfortable with this, and we had to walk through it. You could be setting yourself up unintentionally for a potential violation of the law if you're not careful. So always important, go back to that agreement, look it over, check it out, make sure you're not missing anything. Little things too that come up, where to give notice. Sometimes these physician agreements in particular, I see have a particular location, an email address, where to provide notice. It's a small technical thing, but let's not give the other side any reason, especially if you're dealing with a highly compensated employee who's going to look to nitpick every reason for the termination. So these are just a couple of factors to consider and look when you are going to terminate someone who may have an employment agreement.
Before we go on to the next slide, there's a bunch of questions we're going to bullet through, do the best we can anyway. One of the questions which ties back to the applicable law is, how long after someone comes back from FMLA can we terminate if we are eliminating that position? Is there a waiting period? The short answer is, without knowing any more facts in the particular scenario, is if there's a restructuring and a downsizing that is real, then you implement that. It's not a question of a waiting period. That's what's needed in order for an entity to continue operationally and to continue to remain viable, so long as it's real. It's not, well, if we wait 2 weeks, is that okay? Or 4 weeks? It's not about any waiting period. If there is the need to eliminate that position or to eliminate a unit and so on, and as long as that is done in a fair manner, then you go ahead and you do it. There is no such waiting period that's required.
And just to add to that, there were a couple of questions on elimination of positions. I just had this recently. You really have to do an analysis. Are you actually eliminating that position, or are you just shifting over that person's job duties to somebody else who you think maybe does a better job? And that's an inquiry that will be done, especially if you're coming back from FMLA leave. And it's something that we've touched on a little bit, but I'll be direct about it. You might have a very good reason to terminate someone that's justifiable, that's real, that's correct. It's not retaliatory, it's not discriminatory, it's none of those things. But it may appear to a third party that it has something to do with leave. Or the one we always get is, I want to fire so-and-so, she's pregnant. Well, why do you want to fire so-and-so? It has nothing to do with the pregnancy, has nothing to do with that. But I don't know, 7 out of 10 times, 8 out of 10 times, the follow-up call we get from that person's attorney is, it was because they were pregnant. So you have to keep those practical realities and how things look in mind.
I'm going to tie back on the next slide about the waiting period question, but then there's a question about what's the story with restrictive covenants. It's a broad question. It's, if you can elaborate in the chat room, that'll be helpful. Restrictive covenants, to state it very simply, because we give separate presentations just on the topic of restrictive covenants. There's a proposed rule with the FTC. New York has pending legislation. Nothing's been signed yet. A movement towards eliminating, in many respects, restrictive covenants, but they're still enforceable, if that's what the question goes to. Another question is about the 90-day probationary period. how does that fit into the scheme that we're talking about with employment at will? The 90-day probationary period, a person's an employee at will day 1 and day 500. The 90-day probationary period is just making it visible that there's a proving period that they have to, pass through before certain, not job security, certain benefits may come their way. It can affect in terms of PTO and the like.
Just to that point in the probationary period, you still have to take all these considerations into effect, whether they're on leave, whether there's a discrimination complaint or a retaliatory component to it. Just because they're in that probationary period does not make it any less lawful, to go ahead with the event. Might it be a little bit easier to demonstrate that they weren't meeting your expectations? Sure. What I usually say in those termination notices or when I sit down with the employer or recommend the employer sit down is, we don't think this is a good fit for both of us. Try to start using that language of both of us. It's only been 60 days in your 90-day probationary period. We don't think you're catching on to the job as we had hoped or as you had hoped. So at this point, we're going to separate rather than continue the relationship.
All right, document the reasons for the termination. All right. The biggest challenge that litigators like us face when we get wrongful termination claims is there's a lack of documentation about the performance issue, or there's a lack of objectivity in the documents that do exist. And that, for what should be obvious reasons, presents a challenge, because if you have no documentation or limited documentation or flawed documentation, a jury's going to look at us, or a trier of fact, if it's a bench trial and so on, and say, all right, you say that so-and-so is a poor performer and that was the reason you terminated that person, but you don't have corroboration. And that lack of corroboration is going to weaken your ability to defend that claim, or weaken your ability to convince some plaintiff's attorney that the claim they may pursue isn't worth pursuing. Whether it's in one of the agencies, state or federal, or in litigation and so on. A lot of times we'll say, because one of the first things we ask clients when they want to terminate somebody is, all right, give us the file, give us the paper, the underpinnings for your basis to terminate. And we'll get comments like, well, we spoke several times. They knew about the performance issues. Well, that's nice, but you don't have corroboration. People forget conversations, or they have selective memories due to some human nature reasons of they hear what they want to hear and maybe didn't hear the message you were trying to impart. So the documentation is critical. Performance evaluations, minutes of board meetings, disciplinary records, attendance records, policies that you can point to say, hey, that, like we spoke about just earlier, that they violated. If you haven't documented, it's never too late to start documenting. So what do I mean by that? I'm not talking about backdating documents, obviously, or what I hope is obvious. Okay, what I'm talking about is we'll get a client. So I'll use we're using all examples from cases we've handled over the years. We do a lot of medical staff hearings for hospitals, and in this particular case, the hospital wanted to terminate a resident anesthesiologist for poor performance. And of course, how bad was it? For 9 months, terrible, not a stick of paper, because the reasons don't matter. They didn't have the documentation. So with the program director, we said, look, today, write down everything that was wrong in terms of that he was eating muffins in the OR, he let a patient get incised without anesthesia. They documented today, and then we used that documentation as the basis for going forward with the hearing. Another example, again, like if it's real, then put it down on a piece of paper. And this goes to the waiting period question that was asked earlier. We'll have a situation where someone will have a historic record of poor performance that's not documented. So we'll say document now, A, B, C, D, E, F reasons. Now call them. Well, we want to terminate them now. Well, but you know what? Maybe they're out on leave. Maybe they just announced that they're pregnant, right? And the natural link, at least at 20,000 feet, is going to be, well, you terminated me because I'm pregnant or I'm out on leave. No, you've had this long performance. Now, it's not some defined fixed waiting period. There's not some bright line that says this is when or when you don't do it. What we advise is that you didn't document it. The risk factors are going to go up exponentially if you time it out now. when they are out on leave or they just announced they're pregnant. Sit down with them now and say, here are these performance issues. We've discussed this with you over the course of time. Now you have current documentation. Now what we generally, because every case rises and falls on its facts, now we say to a client or advise, you know what? Now you're better off waiting, because if you do it now, they're going to link it temporally for sure to whatever that reason was that's going to give rise to a discrimination claim. Again, it's about risk analysis, it's about operational analysis, whether or not you can afford to keep this person anymore without replacing them. When we understand the global picture here, but we'll generally advise, wait a little, give them a chance now to improve, whatever that time frame may be. I'm not going to call it a waiting period. Give them a time frame that's reasonable to fix what you've now told them and documented is broken. All right.
Just one last piece. There's a question we got in advance on documentation. When you're, we can go into a lot of detail, which we don't have time for today, about what to put in a good performance review or evaluation or disciplinary warning. But as in general, try to be specific. If someone's late consistently, set forth the dates that they were late. If someone took a longer lunch, put those dates in there. And one thing I always tell folks is, because we understand you're doing 9 million things a day. You don't have time to sit down and do a whole new performance evaluation and complete this form. Try to send yourself an email. Note to file regarding conversation with Andrew Zwerling. Advised him he was late on November 27th, 28th, and 29th. If this continued, I told him he would be disciplined, including termination. Now you have some record out there that you can cite back to that's contemporaneous. How long did that email take? 46 seconds, right? It was simple. So those are some things you can do, and try to provide that level of detail. Obviously, the more, the better. You don't need to write a novel. I don't need a 6-page dissertation unless someone really did something bad that we have to investigate, and we want to make sure we're clear is going to be a justified reason, because there are some underlying issues. But by that point in time, hopefully you have HR and us involved to do that.
Just a logistical message to the audience. Put all your questions in the chat. You can't see it, but the chat has an overlay with the questions and answers, and so we can't see the questions and answers. So for consistency's sake, if you can just type out your questions in the chat. There's a question: can you terminate somebody who's on jury duty? Again, everything, all of these, cases rise and fall on the specific facts. The short answer is that you can terminate someone who's on leave if you have a proper basis. They may allege that it's discriminatory and it's linked to their leave or being on jury duty, whatever the issue may be, and you may want to take that variable into account in deciding whether to terminate, but it's not an obstacle. It's not some absolute obstacle for sure in any given instance. Is an attitude issue a good enough reason for termination? It might be, okay? Depends on how you define attitude. It depends on whether or not other people, convey themselves in the same manner. It may be dependent upon whether or not what one person's calling attitude, another person may say is a cultural issue. Okay, so there's a bunch of issues you're going to want to take into account and consider before necessarily relying on attitude, which can be a basis, but it's kind of squishy. With regard to another question that was on the screen, what's considered a complete write-up for purposes of termination? Again, it's case by case.
So yeah, we'll switch to termination protocols. One thing I think
I just want to give a couple more points about documentation and objectivity. You may document a couple of things to avoid personal comments when you're talking about someone's performance. Overstatements, emotionally charged language, speculation, and things like that, because you'll think, oh, I documented well, but the more flaws that exist in your documentation, the less credible that documentation is going to be, or even worse, in a given instance, the language you use may be tied or support some claim of discrimination. Also, with regard to documentation, you be honest in the documentation. We've had a bunch of cases where our clients have really squirmed during depositions, if not during the trial or arbitration, when confronted, for example, with performance evaluations, with someone who they terminated for horrible performance reviews in a physician setting, deaths of patients, And in their performance review, 5 out of 5, 5 out of 5, for years, right? Okay, be honest in the evaluations, okay? Again, a lot of supervisors are reluctant to be critical. They want to be the nice person, but by being nice and not being honest about performance issues, not only are you not telling the person that they have a problem that needs fixing and giving them a chance to succeed, at the back end, that lack of honesty is going to hurt you when it comes times to pull the trigger.
So shifting back to the termination protocols, and it kind of leads in right from what Andrew was just saying about having supervisors issue good evaluations. We do separate programs and actually trainings where we come out to you folks or do them on Zoom or webinar format like this, where we work with your supervisors and managers on how to properly document these things, how to properly give evaluations. If, for example, with respect to protocols and that's the exact scenario, we had a situation, I've had this a couple of times now, where a decision was made to terminate somebody. And in one particular case, they started talking about it. And you really want to keep that in the need to know group, right? High level. But information got out and it got back to the person who they were going to terminate, that there's going to be a meeting on Monday with you and something's going to happen. What did the person do over the weekend? They filed a complaint with the New York State Division of Human Rights. They sent an email to HR and they sent an email to the manager saying, I've been discriminated against for months. I've been retaliated against, and you're doing all this because of my national origin. Now, there was no basis to any of that. There was a specific reason. And I know what we're saying is take your time and be diligent in getting everything in place, but you have to keep it under wraps. You have to make sure it's within the know, and you have to train your management and staff to say, you don't communicate this outside. Because in that case, it's a 3.5-year dispute that we actually just settled last night late, that we had to defend, that was really baseless. But because of the timing of everything that took place, there was enough out there for a very liberal group in the Division of Human Rights to say, well, let's let it go to a hearing and a trial. So keep that under your protocols, keep the circle tight. Once you do make the decision, be prompt, be ready to move on it and act on it. Try not to put it off for weeks at a time. I've had situations where, and related to a documentary issue as well, person was going to be terminated. They had planned to do it. They sat down with the meeting, and instead of taking over the course of that meeting and explaining what it was about, they started with, is there anything you'd like to share with us? And the person just said, yeah, I have cancer and I'm going to be out. So they decided to go forward with the termination anyway, because they didn't step out and think to call us, but they went forward. They fired the person. We got hit with a discrimination lawsuit. And again, the timing of it looked terrible. Now, they could say all they want. I was ready to terminate the person, but the job evaluations had 4 out of 5s and 5s out of 5s across the board. So we couldn't use that as support. The only thing we had was the memory of the manager who said, that was my plan to do that day. And unfortunately, that's only going to get you so far when you're defending yourself and your company. So keep those things in place. Other protocols to keep in mind, you have to issue a written termination notice. It's something that gets overlooked all the time. You have to do it immediately. You have to do it within days. This isn't something that can wait 2, 3, 4 weeks. Okay, it has to be within a couple of days, depending on what jurisdiction you're in. And depending on where you are, you have to issue your wages within a certain period of time. So New York and New Jersey, for example, it's going to be the next pay cycle. Connecticut, however, you're going to have to actually issue the outstanding wages the next day. So you've got to be ready to get payroll on the horn and say, okay, can you issue a check to Sal for the wages through Thursday? And that's going to cause a little bit of, maneuvering on their part, because they usually don't run payroll till the following week. So these are things that all have to go in this termination notice. A record of employment, you have to notify the employee of, this is the employer. You can submit this form to unemployment. Information about their benefits. I had one situation where an individual was terminated, and one of the claims that was made on his behalf is that he did not get the proper COBRA notification, and therefore he missed his COBRA benefits for the first month, and it cost him $14,000 in copays and everything else. Now, underlying that, it was nonsense, because he knew the information. He was the guy who created the program. He was the person at the company who set it all up. He knew where everything had to go. He figured it out on his own, but he used that against us as a technical violation. There was really no defense because we didn't have the documentation. So when you go through this, sometimes you might have protocols with the HR companies you work with lawyers like us, or your HR department internally. Make sure you know what those protocols are, follow them, and try to get the information out as timely as possible moving forward.
There's a question, should we try to pick a reason, or can we just state that it's not working out the way we anticipated? For example, The employee is nice to their supervisors, however, colleagues and coworkers are complaining but don't feel comfortable writing the statement. Yes, you can do that, but think about the risks associated with that, right? You're now telling the person, we'll talk about protocols on how to deliver the message momentarily, and you just tell them, they say, well, why am I getting fired, right? And you go, well, it's just not working out. The person is going to be sitting there, one, they want to know why, and you should tell them why. But if you don't give them some explanation, and we're not talking about, you don't have to document your reasons in the notice of termination that's required, but if you don't give them any information, they may sit there thinking, you know, it's because I'm a member of a protected class, or it's because I filed that complaint, I'm a whistleblower. It's because I filed that complaint and this is retaliation. Oh, it's because I was out on jury duty for 2 weeks. You know, I'm just borrowing some of the questions, right? That's where they're going to turn. It's too ambiguous and open-ended, right? And you want to diffuse that because that's not the reality. You know, we're all working on the premise that you have a valid justification for the termination. So as a practical matter, you want to explain to them why they're being let go. You know, the less you give them, the greater the likelihood that they're going to speculate in some misguided kind of way that might come back to hurt you.
So just another quick topic, and this one will be brief. Gather and assess relevant information. We've touched on this a little bit about having your information together, but when you are ready to go forward with termination, you're going to have everything. If you're going to give the person a separation agreement, have that ready. Understand how to deliver that. We'll talk. There'll be a separate slide to talk about those and the benefits later on. But be prepared with any other disciplinary warning notices and information. Have that in the file. You don't have to have it with you when you're going to issue the termination, but have it there. You may want to be able to refer to it if the employee questions you or says, well, wait a minute, you never told me about this. You say, well, we don't want to get into that, but we've notified you on several dates that you were late, that you were tardy, that you weren't doing the job correctly. If nothing else, it's good to have that information all organized and gathered in case an issue comes up down the road. Hopefully you never have to use it. Hopefully it stays in the personnel file and that's it. The person collects unemployment for a bit and gets another job and everybody's the better. But in worst case scenarios, that won't happen. So I have two cases right now where one, we have the documentation all gathered. It's in an email. The client has it. We have it. If an issue comes up, it's there. We can refer back to it very easily because asking someone to collect that information, gather and put it together 3 months from now, 6 months from now, a year from now is going to be that much more difficult. Number one, another case I have right now, it involves a physician and it's going to be a highly contested restrictive covenant issue and a payout issue we're dealing with. And the physician's been maneuvering for months and he's got an informant on the inside. So now we're tightening things up more about what's going on. So we've got a lot of documentation in place and a lot of information that we're prepared to go forward with that hopefully he doesn't know about in terms of where he's going to be practicing, how he's violating the restrictive covenant that's in place, and what steps we're going to take to do that. It's better to have it now before the actual termination event than working from a reactionary standpoint.
All right, best practices for delivering the termination message. To effectively communicate a termination message, it should be carefully worded, and the people, plural, who deliver the message should be trained in how to do so. So what are some of the best practices? Time the decision to allow for privacy. You know, figure out where that meeting is going to take place in terms of the location, the time of day, where you're going to minimize the possibility of somebody walking in the room while you're delivering this message, okay? Seems obvious, but in cases we've handled, it appears to be less than obvious. So it could be before the workday begins. It could be at the end of the workday when people have left. You know, choose a private meeting place that's kind of outside the flow of traffic if that's available to you. Prepare and even rehearse the delivery of the message. You know, don't wing it. Remember that although the termination is justified in your view for whatever the reasons may be, you're about to turn somebody's world upside down. And you want to make sure that you deliver that message in the most professional manner possible. So the message or the talking points should be rehearsed, you know, before the actual meeting. I'm not saying you have to stand in front of a mirror and practice, but you should have your talking points ready and feel comfortable in how you're going to deliver it. Not that you can always predict how those conversations are going to take place or transpire, but do the best you can. Even having a piece of paper that has the bullets, that's what helps get you through the moment, then do so as well. Have a witness. Don't do it by yourself. Have two people in the room. Right? So you have somebody to corroborate what's going on. It also allows you, if you're the one delivering the message, just to focus on delivering the message. Let the other person be the witness to record the give and take that goes on. Be direct. Make the necessary points without making excuses or minimizing the reason for the decision. Avoid personal attacks and so on. Make sure that person, and this goes to the question before about, can we just say it's not working out? You want the person to understand also not just the reasons, and you don't have to give 3 hours on it, right? You can give the bullet points. You also want to make sure the person leaves the room, because we've had this too, understanding they've been terminated. Because we've had those instances, we go, Bill, it's just not working out the way we hoped it would. Your performance really hasn't. We thought you were going to be doing much better than now. So we don't think this is really working out. Yeah, I understand, right? You don't have a clarity.
That's a Seinfeld episode.
Yeah. Avoid arguments. Don't enter into arguments regarding the decision. You've made the decision, okay? Be open to questions, be open to feedback, because you may want that feedback and to use in going forward with regard to any issues that may exist in the workplace that you are otherwise unaware of. Be prepared for a negative response. Again, let's face it, right? None of us have encountered a situation where we've been part of a termination and the person goes, Zwerling, Puccio, you're right. I'm terrible, right? I've been a poor performance since day one. People aren't going to walk away or have that self-awareness. It's just not rational or normal, right? So be prepared for that, okay? But stay firm, because you've presumably done a lot of thinking and have documentation to support this decision that you're going to make. In situations in which an extreme response is anticipated, and we've had those too, prepare in advance if you need security. I had one termination when I was a prosecutor in Queens, and I was an executive assistant district attorney where the person being terminated had threatened to supervise physically. So we had a couple of rather large detectives in the room just as a safeguard, as a safety measure. Keep those thoughts in mind. It's rare, but you may face that circumstance. Don't interject, and this is a big one, personal statements, because we've seen that. Like I said, we wear two hats, so we see that in a litigation context where all of a sudden the plaintiff or some other witness says, oh, during the termination, the person who terminated me said, look, Joe, it's not my decision. If it was up to me, we could have made this work, but I'm not in control here. Don't do that. Avoid those kind of comments. You think you're being the nice person? Well, you're terminating someone, so there's no way they're going to view you as the good guy. All right. So at the end, that's only going to lead for you being a witness on behalf of the plaintiff, undermining what was otherwise a justified termination. Outline, as Sal said, the status of employee benefits. Discuss the reference situation if it comes up. Maybe you have a policy that you just give title and dates of employment. That seems to be the norm. Be sensitive. It's a termination, again, should be obviously, but it's a difficult and emotional manner. And so, take that into account when you're having this interpersonal dialogue.
And just a quick point on this. So we also at times represent individuals. We might represent a high-level employee, C-suite employee or physician who's getting terminated. And I'm dealing with one right now, and I haven't even had a chance to talk to Andy about this, but it's really interesting because we're on the employee side, and all the things that Andrew just talked about in terms of the best practices, this employer is not doing. And it's making, the individual I'm working with frustrated and want to go back at them. And the substance of what the employer is doing is actually correct. They're changing a bunch of job terms, which they can do. They're asking for him to sign a new offer sheet, which they can do. But the way they're delivering the message is that he's got the owner who he knows and has a personal relationship with the company saying, don't worry, you're going to make more money. I'm going to pay you this bonus. I'm going to pay you this. I'm going to do this. Then he's got this manager who's dealing with him, giving him a term sheet that doesn't match up. And I'm looking at it as a neutral third party saying, well, someone's lying to you here. And the best bet is both of them are lying to you here because they can't get their story straight. So this guy right now he's fired up. He's looking, how am I going to go after them? How can I hurt them? What's the best way that I can benefit myself and at the same time screw them? You don't want to be in that position. Just sit there and have a conversation. It's not working out. These are the issues. Be uniform. At least the employee knows where they stand, right? And that's it. You can move forward.
There's a question. We will legally advise not to give reasons when terminating an employee so they can't use anything we say against us in a lawsuit. Is that valid? Based upon what we've shared with you thus far, we don't agree with that position. You should tell a person why they're getting terminated. Otherwise, what are you going to walk in and say? Billy Bob, you fired? That's it, right? It's going to instill in them, the notion that they're being terminated for some wrongful reason. I was out on leave. It's retaliatory. It's discriminatory. All those things we mentioned. Okay. The other thing is, it's not even, you're not giving them a chance to respond. And I'm not talking about some cathartic process necessarily, although that's part of the equation if you're treating people like human beings in these difficult settings when you're terminating them. But you also might get valuable feedback. If you say, look, we're firing you because of X, they may tell you information, like we just said a couple of minutes ago, that might help you run your workplace going forward. Or we've even had cases where the information that came out of the person being fired led to another termination. We had one where a young man, it was his job fresh out of college, first job out of college, and a female colleague says sexual harassment. And she shows the managers all these texts showing that this young man, in the most graphic way, was saying things that, let's just say, would be inappropriate for the workplace. So they go, all right, they call the young man in, sexual harassment, here are the texts, and so on. He's got his head in his hands. It's like, I can't believe this. I have a girlfriend at home. How do I explain this? I'm getting fired, my first job. And okay, valid termination. And he goes, did you see the other texts? And proceeds to show the pre-existing text that showed that she initiated this whole romantic relationship and stuff that was going on at the work site. Okay. His feedback, when told the reason why he was being terminated, informed them that part of the problem was the female colleague who also was terminated. So again, there's very valid reasons why you want, to some degree, to give them information. You don't have to give them chapter and verse, but you want to give them some framework to work out. Again, to minimize the risk, they're going to go to some lawyer who's going to say, they didn't even tell you a reason? Okay.
And there's no absolutes in any of these things, right? There might be a strategic reason in a particular circumstance where you're going to be vague. So, that's something you have to deal with on an individual basis with us, where we can look at it and play ahead. Okay, well, maybe we're vague here because maybe more information will come to light down the road. So it's a consideration, but, again, there's really no absolutes.
This will just zip through, basically just document the details, who was present, what was said, with regard to documenting the termination event itself. What we'll do is we're going to move to the next slide to capture some other salient points.
And just a few pieces here on additional considerations, and we know we got some questions on this, but what do you do now? Someone's gone. How do you get back their information, documents that they had? Confer. You might have a non-solicitation agreement, confidentiality agreement that speaks directly to getting back certain types of information. So that's important to do. We've talked about a lot of issues with respect to planning for potential violent situations. We won't go through those, or morale, publicity issues. Keep in mind, if you're a bigger employer, it's a hot button topic, there might be some press. So you might have to consider or plan for a contingency related to that kind of information. One thing, especially for our folks on the line that are healthcare providers, you need to have something in place where you can wipe someone's device, their laptop, their cell phone, whatever they might have, or whatever access they might have that you can shut off. It's going to do two things. One, you're going to be legally required and obligated, but two, you don't want them running around with your patient list. I have 3 cases right now where the doc left with the patient list and we're fighting to get it back. I've done stuff where we go out and we wipe the laptop that they have and their computer, and I get an affidavit from the forensic accountant, a forensic an investigator to do that on the IT side. Those things all cost money. It's going to cost legal money. It's going to cost vendor money. So have those policies in place that could help you set that up. I had one case where a person left. We asked for the laptop back, fighting back and forth. Finally, we sent the TRO notice out to the lawyer and said, I'm filing this in the morning if I don't get the laptop back. The laptop comes walking in the door. They said, okay, great, we got it. Are we done? I said, no, you're not done. Analyze that laptop. They've had it for a month. What the heck did they do with it? Sure enough, we've got the owner of the other company who's a competitor operating it, trying to hack into our systems. So what I said is, guys, you got to do a better job protecting that information before it ever gets to the owner. Have some systems in place. And again, this is all, value type based decisions. Depending on the size of your company and the value of this information, you'll add more protections. A lower level employee who might just have a cell phone to answer service calls, just wipe it, clean it, and you might be done.
And as far as the wiping, do it as soon as possible, because we've had cases where people were told they were terminated, still had access to the system, either on site or remotely, and either stole files or deleted files. As far as collecting property, or should you walk them out the door, again, case by case. Sometimes, especially with remote employment being part of the landscape, sometimes the terminations are being done by telephone or by Zoom, so you don't have that issue. There are other occasions if you're terminating someone, yeah, you're going to want them to leave right away, because why would you want someone who's been fired walking around your workplace? There are what should be some obvious negatives associated with that. As far as collecting property when someone's terminated, again, if they're there, laptop, cell phone, badge, swipe cards, and things like that. Get as much as you can right there, right? Because it's going to be a lot harder to get it from them once they leave. There are things that you can do in order to get back equipment once it's, if it's still off site, trying to recover that from a terminated employee, it's difficult. So try to do the best you can while they're there. There's a question about, is there a time frame? Can you hold back the last paycheck before you get the items back? Again, we cover 5 different jurisdictions. The law is different in each jurisdiction, so you want to pay careful attention to what each jurisdiction allows you to do. But for example, in New York, you can't hold back wages. Let's say, I'm making up the numbers, someone's due $5,000 in their last paycheck, and they stole they haven't returned a $10,000 piece of equipment. You say, well, I'll just hold back the $5,000 and, cut my losses. In New York, you can't do that. If they're wages, you can't hold back wages for reasons like that.
Most states are going to be the same too, but again, it's important to check.
Right. But for example, in New York, you don't have to give employees accrued PTO when they leave. You can condition them being paid accrued PTO. And so you may want to consider revising your policy, because you have to do this in writing. You give them notice in writing that the payment of accrued PTO is being conditioned. Usually it's you have to give notice of when you're going to leave of X amount of time, but you may want to consider conditioning the payment of that accrued PTO, if they have any, is conditional upon the return of all property. So if they're due, making up the numbers again, $2,000 in accrued PTO, and they're holding on to a $2,000, piece of equipment, if your handbook has already said this, you will be able to offset that. So there are things you want to take into account before you get to that point that might help take the edge off of that financial hurt if they don't give back equipment.
A few small things, little tricks that we picked up in the last couple of years, especially in the remote time period. Some employers, what they've done, have been creative to say, Andrew, can you come in next week? We got to do some maintenance to your computer. And that's the day of termination, because you fear you're not going to get that computer back and you're really concerned what's on it. So maybe there's some, trickery involved in that, but it's legitimate if you want to get that back. Got other clients call and say, can you go down to Georgia and get this laptop? Sure, I'll go get a lawyer down in Georgia for you. How much is the laptop? $750. Okay. The retainer is going to cost $2,500. Do you really need that laptop? No, I don't. So, those are the kind of discussions we might have. Also, when you are terminating someone, we're going to cut off all their internet access or their email access. You need to make sure you have a way to communicate with them. So make sure a private email. I've run into this lately where the person moved. It's very fluent out there right now. Your employee who you thought was living in Queens is now living in Connecticut, and you don't have a forwarding address to send the termination notice or the benefits information. So try to piece together, keep your HR records up to date. I've had this a couple of times now where we're saying, where are we sending this? How are we going to get this notice out? We need to get it out ASAP. So just keep those little things in mind that don't come up until it's too late. Waiver and release agreements, just quickly, because it's really a whole separate topic, but these can be your best friend. What we try to do in these situations is you pay a little bit of money up front to get a release of all claims, or as many claims as you can. Some claims might not technically be releasable or have some carve outs, but you can do a pretty good job of covering yourself and getting released if you give sufficient consideration. And what I mean by that is, it's a question that comes up often in this context. You can't say, to feed off of what Andrew was just saying, I'll pay you your last wage, your last set of wages in consideration for this release. No, they're entitled to those wages. That's not legal consideration in our world. What you have to do is something above and beyond what the individual is owed. So that might be 2 weeks pay, 6 weeks pay, 4 months pay, whatever the number is that you feel comfortable with that you can issue. We understand it's difficult because you might want to give someone more time who is a better employee. Maybe you create an internal policy that based upon the number of years you're there, or you're just going to do it ad hoc and figure it out as time goes on. But there are some additional restrictions lately on these agreements, like confidentiality, non-disparagement, that you have to consider in certain states or certain areas. But for the most part, by and large, I think the waiver and release agreements are a great way to go, help get some closure, help get some understanding. One practical tip I'll give is, if you have an employee who you think is going to be a bit of a pain in the neck, and they've been a pain in the neck, and you don't think they're going to accept the first offer, and I just did this in a case and it worked perfectly. We said, all right, what are you willing to give? And he said, I'll give 4 weeks. I'll give a month. Okay. When you write the separation agreement, put 2 in there. But I want to give 4. Put 2 in there. We put 2 in there. They got a letter back from the lawyer, discrimination, disability, blah, 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 blah. I said to the lawyer, look, I'll do the best I can because I'll give you 3 months, 3 weeks. We went back and forth. Where did we end? 4 weeks. So we ended where we wanted. The employee thinks we moved it up. The lawyer on the other side feels justified in his fee because he moved it from 2 to 4 weeks. But in reality, that's where we were at. So you're not going to be able to do that in every situation, but you might be able to do it in some. Some employees, it's a good person, you're just separating. You know what? Here's 6 weeks. That was what I was ready to give. And they take it and they go. Some situations you might give 6 and they want 10, you tell them no. And that's the end of it. But factor that in with who you're dealing with.
Just going to make 2 quick points with regard to practical tips. As Sally mentioned before, if you're going to terminate somebody, do it as soon as possible. Don't wait, because if something happens in between, they have surgery, they become pregnant, and so on, you're going to leave yourself open to a claim that it's retaliatory and discriminatory and so on. The second point I want to make, because this has come up several times, once you decide to terminate someone, document the decision, the intention to terminate right away. Don't wait for the termination event itself, the delivery of the termination message. Okay, document, we're going to terminate so-and-so next week, whenever you're going to do it. And the reason why, and I'll give you an example to illustrate the point, and these are actual facts. On a Friday morning, the head of HR at our client wrote an email to the head of the department saying, we're going to terminate, Billy Bob on Monday. Well, Billy Bob got wind that Billy Bob was going to be terminated on Monday, and Saturday night, Billy Bob sent an email to the head of HR with a doctor's note saying, effective immediately, I'm going out on FINRA leave. And the client called up and said, what do we do? We're going to terminate Billy Bob on Monday morning. But they showed the email string showing you already made the decision. It's in writing that you were terminating Billy Bob for X, Y, and Z reasons on Friday morning. Again, it's up to the client to make the ultimate decision, but our advice was you fired Billy Bob. I mean, let's just say that the justifications were deep and profound for the termination, and the fact that they documented that before this FIMLA notice came on a Saturday night, that your intention to terminate occurred before the FIMLA notice, that's a pretty solid defense to any FIMLA claim that might arise. And none did in that particular instance, as an aside.
You have that CLE code?
Yes, we do. All
right, for those seeking CLE, I'm sorry, it's a little late in the program, but the code is B as in boy, P as in Peter, T as in Tommy, 1129. Again, that code BPT 1129. All right, so I think that concludes the substantive information. We have some questions there in the box. We've tried to answer that the best we could. If there are additional questions or particular circumstances, feel free to reach out. We'll continue doing these seminars. We have a couple other great programs coming up with some of our colleagues on other hot button HR topics. And like I said, we're also available on the counseling side as well as the litigation side and the advisory side, coming in and doing hands-on trainings, presentations, those kind of things.
Yeah, someone just asked, can we repeat the code?
B as in boy, P as in Peter, T as in Tommy, 1129. BPT 1129.
All right.
All right. Well, thank you, everyone. We appreciate the time. Thanks for sticking with us till the end. We know we went over a bit, but definitely a lot of information to cover here, and I'm sure there'll be more to come.
Thanks, everybody.
Thank you.